So I think we have a critical mass. Welcome, everybody. My name is Daniela Knoppig, and I work with UNICEF's Global Migration and Displacement Hub. And I also represent UNICEF on the Interagency Coordination Group Against Trafficking in Person. And it's my pleasure to welcome you to this webinar today. We'll have the next 90 minutes to dive with you into the topic of strengthening justice for children in the context of trafficking. In terms of housekeeping rules, as you can see, we are going to record the webinar. And we have disabled the microphone and video just to make it a bit more easy for us to manage the webinar in case we have a big group of participants coming in, but we do have the chat open. So please make use of the chat to ask questions, share resources and comments, as we want this to be a lively webinar. And this webinar is part of UNICEF's engagement in ICAT. And I think most of you are quite familiar with ICAT, but for those of you who are not, ICAT is a policy forum which is mandated by the UN General Assembly to improve coordination among UN agencies and other relevant international organizations to facilitate a holistic and comprehensive approach to preventing and combating trafficking in persons. And UNODC is holding the ICAT Secretariat. So we're quite excited to have two of our colleagues on the call today representing UNODC and ICAT, Mukundi and Nora, and you'll see them on the camera and list of participants. And the ICAT chairmanship is changing on an annual basis. This year, ICAT is co-chaired by the Office of the Special Representative of the Secretary General on Violence Against Children. We're quite excited to have our colleague Thea with us today. And as second chair, we have IOM represented by our colleague Hannah today. So coming to today's focus, why the focus on child victims? So if we're looking at the most recent TIP report from UNODC from 2022, around 35% of all identified victims of trafficking are children. And migrant, refugee, and IDP children are particularly at risk of being trafficked. And whether they're escaping war and violence or lacking opportunities at home, too few children find pathways to move legally and safely. And in the absence of legal opportunities, children and their families often choose irregular channels to move, and children often moving on their own, which can then leave them more vulnerable to violence, abuse, and exploitation by traffickers. And a recent report by UNICEF and IOM showed that 8 out of 10 adolescents and youth that have crossed the Central Mediterranean route reported exploitation. And this is even more so the case when these risk factors are coupled with inadequate education, healthcare and social protection systems, poverty or discrimination. So how does this link to the justice system? Access to justice for children is central to UNICEF's mandate and the implementation of the Convention on the Rights of the Child. So access to justice is not just a fundamental human right, but also a means to enforce other human rights. And yet in practice, children's access to justice is often overlooked. So many children are still facing enormous obstacles. For example, disabling cultural norms and attitudes, a lack of knowledge among families, communities, children regarding their rights to protection and the availability of resources. And we also find that often systems do not recognize their rights or do not have child-friendly processes and procedures in place. So we want to use the next 90 minutes to really dive with you into this topic and reflect on specific barriers that child victims of trafficking are facing when it comes to accessing justice and including in the context of online sexual exploitation and abuse. And we'd also like to use this opportunity today to identify with you priority actions to strengthen access to justice for child victims of trafficking and linking this to UNICEF's Reimagine Justice for Children agenda. And we have quite an exciting group of presenters today, some of my UNICEF colleagues from IOM in Romania, and we're also excited to hear from colleagues at ICAT and Interpol's Human Trafficking Expert Group. And as you see, we have quite a full agenda. So again, please do use the chat to engage, ask questions. And we're also keen to hear at the end from you if you're interested to potentially have a follow-up conversation around some of the topics that we'll dive into today. But without further ado, I'd like to hand over to my colleague Tia Machaidze She is a child protection officer at the Office of the Special Representative of the Secretary General on Violence Against Children, and ICAT co-chair this year, to start us off with some reflections. Over to you, Thea.
Thanks a lot, Daniela. On behalf of the co-chairs of ICAT, IOM and SRSJ on violence against children, I would like to thank, first of all, UNICEF for organizing this important event and welcome you all to the webinar. The issue of access to justice for child victims of trafficking is of particular significance for ICAT, as countering trafficking in children remains a central focus within all the thematic priorities of our work plan this year. In particular, ICAT has a dedicated work stream that aims to promote the rights of victims, especially children, the implementation of non-punishment principle, and access to justice informed by the perspectives of survivors and frontline actors. Within this workstream, we advocate, among others, for ending child immigration detention and enhanced protection of unaccompanied and separated children who are at heightened risk of becoming victims of trafficking. Under this priority area, ICAT has already successfully completed several activities. Notably, our joint submission to the EU Anti-Trafficking Directive conveyed important messages regarding the need for stronger safeguards and measures to protect child victims of trafficking and ensure their access to justice. This includes the prompt appointment of legal guardians to represent and help children navigate criminal investigation, but also immigration, status determination, referral, care, and other critical processes and proceedings. In her co-chair role, the special representative continues to actively engage with anti-trafficking actors in the context of country visits across all regions. We see progress being made in reforming legal frameworks to safeguard the rights of child victims of trafficking, establishing child-specific referral mechanisms and cross-border cooperation frameworks, as well as child-friendly administrative and judicial mechanisms. However, there are still significant obstacles. Despite the non-punishment principles, many child victims of trafficking find themselves in immigration detention or deprived of liberty within the criminal justice system for acts committed as a result of being trafficked. As a consequence, children who are unsure of their legal status or fear prosecution often hesitate to seek help. Access to information, specialized legal aid and representation is not consistently guaranteed, and child-friendly procedures are not universally in place. Furthermore, children are not uniformly afforded legal protection. Their entitlements and access to assistance vary among countries based on multiple factors, and this includes age, nationality, immigration status, and formal identification as a victim or potential victim of trafficking. In light of all these challenges, access to integrated national and cross-border child protection justice systems that are accessible to all children without discrimination is of critical importance. This is highlighted in our joint advocacy brief issued by several ICAT member entities on the protection of children on the move in times of crisis. It is also in this context that the UNICEF Reimagine Justice agenda assumes paramount importance. Today, as we will have an opportunity to deep dive into specific barriers that child victims of trafficking face, including in accessing justice in the context of online sexual exploitation and abuse, we hope to promote better understanding of existing gaps, but also identify promising practices as well as priority areas for enhanced collective action. As part of our joint commitment to strengthen the engagement of civil society organizations in ICAT's work, we're particularly happy to have, in addition to ICAT members, CSO partners such as ECBAT, contributing to today's discussion through its valuable expertise, and experience of working with and amplifying the voices of child survivors of trafficking. Considering our time constraint and interesting presentations ahead, I will stop here. Thank you once again for your participation and looking forward to your active contributions to the discussion. Thank you, and over to you, Daniela.
Fantastic. Thank you so much, Tia, for these welcoming words. And colleagues, if you have any specific questions on ICAT, please don't hesitate to use the chat. I'd now like to hand it over to my colleague, Grace. So Grace is joining us from New York today. She's working as a child protection specialist and leading our justice work in UNICEF's Child Protection System Strengthening Unit. And she will introduce us to UNICEF's Reimagined Justice for Children agenda and how it relates to our work on combating and preventing trafficking. So over to you, Grace.
Thank you so much, Daniela. I joined the child protection team in New York, but I am presenting from Manila. So I think I don't know if I'm in the time zone of Guillermo. So, but it's a perfect timing. So thank you, colleagues, for inviting UNICEF. I know we'll just start the ball rolling, Afruz and I, but I'm sure ECPAT and our colleagues on the ground will have so many things to share about this topic. Again, thank you, Thea, for your introduction. I hope my presentation can be seen. If not, Thea, can you see it now?
Yes,
Is
it's
it
coming
okay?
up.
Yeah.
Yep.
Thank you. So again, thank you so much for inviting us, Fruz and I. But just to frame where the Reimagined Justice for Children agenda is coming from, as you know, all of us have endorsed the Child Protection Strategy in 2008. Many of our partners, Save the Children, Plan, ECPAT, are using the Child Protection Strategy of 2008, of course, and we have revised it together with our partners as well. And this is part also of the UNICEF strategic plan. These are two separate documents wherein the Reimagined Justice for Agenda is situated. I'm just emphasizing that the strategic plan is a 5-year document for UNICEF where we put our contributions to the achievement of the Sustainable Development Goals. In the said strategic plan, of course, you will see the contribution of health, education, child protection, social protection, and our colleagues on water sanitation as well as climate change. In the said strategic plan, gender is a strategic cross-cutting intervention. But when it comes to the child protection strategy, it's a 10-year strategy wherein we have 3 key elements: universal prevention, leaving no one behind, and response and preventing recurrence. But the key strategy in this intervention is the emphasis on prevention. Our work on civil registration, our work in parenting, our work in ensuring that access to justice is not only able to respond but also prevent violations of child rights is very much part of universal prevention strategies. Under this goal area, we have 3 focus. One is protection from violence, exploitation, abuse, and neglect, promotion of care, well-being, and justice, as well as a promotion of harmful practices. And we ensure that this is in times of humanitarian, peace, and development. And also we focus on social and behavior change, knowing that capacity building, institution building, legal reform is not enough to change children's access to justice. Just a brief overview, we know that the child protection system has 7 intermediate outcomes. First is the legal and policy framework. Thea has mentioned what ICAT is also doing. So our colleagues in the ground, in our field offices, are also supporting government to make sure that the legal and policy framework does not only cover and the entire gamut of child protection systems, but making sure that all offenses, including trafficking, are included in their legal framework, governance and coordination structures across child protection systems, including health, education, social protection, as well as vertical and horizontal coordination, especially for those that have local government or decentralized system, making sure that the continuum of services is there, making sure that prevention, response, and reintegration is a continuum, a seamless continuum of services, making sure that there are minimum standards and oversight mechanisms. Later on, I will be showing also how we work with Children's Ombudsman, National Human Rights Institutions, to make sure that they also put children's rights agenda, including trafficking, in their oversight mechanisms. And making sure also that once the parliament has passed a law, they don't just stop on passing the law, but making sure that they review and have oversight mechanisms, as well as budget in ensuring that these laws are implemented. Human, financial, and infrastructure resources, mechanisms for child protection, participation, and community engagement. But later on, we will show how also we want to empower children and not just promote child participation. And last but not the least, on data collection and monitoring systems. The Reimagine Justice for Children agenda falls within this child protection systems strengthening approach and has 6 key policy asks that our colleagues on the ground are working on. First and foremost, we want to make sure that every child knows and can claim their rights. In the past, our work on justice for children strengthening has focused more on what we call the duty bearers, or what economists would say that, the supply side, training police, judges, social workers. But now we have to make sure that the children themselves, victims of trafficking, unaccompanied and separated children, are know their rights and can claim their rights, that they are empowered to have their rights either through legal guardians, through their parents, families, etc. And can second, they can access free legal aid, representation, and services. We work with other UN agencies on this, but we want to make sure that when that a country has a law, it also prioritizes children, child victims, survivors of trafficking, as well as children in conflict with the law in their access to legal aid, representation, and services. If the government cannot provide for that, we train civil society organizations, bar associations, and other NGOs to make sure that these children can have access to free legal aid, representation, and even translation services. For many of these migrant children, language is a big barrier for them. Sometimes the law is there, the social service workforce is there, but also the attitudes of the social service workforce in making sure that we don't have xenophobia when we approach these children. Third, if a child is in conflict with the law, they can be diverted and provided non-custodial measures. They are protected from detention, and every child survivor of sexual violence, abuse, and exploitation will receive justice. And my colleague Afruz will be focusing on this pillar, and that they can access alternative dispute resolution, and that the courts are child-friendly. All these are interconnected, of course. All of these pillars are important to making sure that the child is empowered and can have access to legal aid, and that they have access to justice. As we've mentioned, the state accountability for the human rights of children is at the center and forefront of the Reimagine Justice for Children agenda, but we know that it is everyone's business. The focus is on non-discrimination, whether it's a child with disability, with different ethnicity, a child on the move, that they are able to access justice within the jurisdiction of this country. And where there are cracks, the regional body should be able to make sure that they can step in and ensure that they have protocols, bilateral agreements to make sure that the child can access justice wherever he or she is found. At the center of this agenda is a call to end the privation of liberty in all its forms, and later on we will be discussing what forms are we talking about, in line with the study of the global study on children deprived of liberty. But the new intervention on this Reimagine Justice agenda is the focus on legal empowerment, so that children with lived experiences of trafficking are able to voice their opinion on what legal reform they should change, focus on victim-centered responses, on child-friendly, gender-responsive mechanisms and courts. We know that the ICAT has produced an issue brief on non-punishment of child victims of trafficking, and we are one with ICAT in ensuring the non-punishment principle. But we know that many countries still do not follow the non-punishment principle, making sure and child victims of trafficking, as you mentioned, are victims of exploitation, and because they are victimized, they are exploited. Sometimes most of the time they are forced to commit illegal acts, and they are punished under the laws of different nations, especially those that do not yet follow the non-punishment principle. Again, our focus is to make sure that child victims of trafficking are victims, but we are aware that some of them are still detained or deprived of their liberty. The definition we're using here on children deprived of liberty is any child who cannot be permitted to live at will. Hence, children deprived of liberty in institutions, whatever you call it, youth reception, rehabilitation center, if they are not allowed to live at their will, it is called an institution, especially closed institutions. Children deprived of liberty for migration-related reasons. We all know that the CRC, CMW already has issued concluding observation on this, that in no case should migration-related deprivation of liberty allowed. But we also know that children can be deprived of liberty on national security grounds. My colleague has mentioned the issue of the Mediterranean, where I was assigned last in Colombia, Venezuela-Colombia border. We all know that some children are also victimized by different syndicates when they cross the borders, and on different conflict or armed violence that can appear in many of these countries. Children living in prisons with their primary caregivers, as well as children deprived of liberty within the administration of justice. We know that there's no magic solution, but we are asking our colleagues in the ground to make sure that we invest in all 6 actions of the Reimagined Justice Agenda, making sure that we build the capacity of institutions, the duty bearers, but making sure that we also provide legal empowerment to the children, especially on grounds of non-discrimination. Again, the priority on prevention and early intervention, to prevent contact with the justice system, to engage social service workforce and other sectors such as education and health, especially on mental health and psychosocial support, build the evidence and make the case of the harm impact of putting children in institutions, supporting restorative justice models such as diversion and non-custodial measures, making sure that when they are released, and we advocate for their release, that they are supported with their reintegration, and to strengthen data systems. We also work with different agencies, and we are part, of course, of different UN bodies, and as well as different organizations with civil society, on making sure that we advocate effectively and intentionally, moving away from the measure of last resort language, providing evidence of what works, clear position on child immigration detention. As I've mentioned, the CRC and CMW has already issued a statement and a concluding observation on that. On legal empowerment, we want to make sure that there is investment in legal rights awareness. We have colleagues in YAPRO who had made a study and who are building the capacity of different civil society and pro bono legal aid to make sure that they provide legal aid to unaccompanied and separated children, to children of ethnic communities, and to children with disabilities, making sure that children's legal standing and right to be heard is recognized, and there are clear mechanisms, and not just putting it in the law, but making sure that there is mechanism to make sure that we hear the child, legal aid, representation and services, integration of social work, specialization within the justice sector. We have so many manuals together with UNODC and other partners, but I think the key is also social and behavioral change, and for our justice actors, to change their also making sure that they are child friendly does not only involve training of skills, but changing their attitudes about children, especially those children on the move. Support for strategic litigation, not just on environmental issues, but making sure that we also use maybe class suits or strategic litigation to make sure that children victims of trafficking or survivors of trafficking can also claim their rights through strategic litigation. On legal empowerment of children, we focus on four key strategies, making sure that children are educated on their access to education regarding their legal system. We know some countries have kids' day in court. They simulate what will happen within the court. So there are many other activities that are child-friendly in nature, which will make the child realize what a court system or a legal system is, making sure that they are able to express their views freely about issues that affect them, and not just a testimony of whether or not they were a witness to a crime. but making sure they're able to express their opinion on what is the proper resolution of the case, access to remedy, and making sure that they are also disclosing their testimony in a child-friendly and safe environment, because at times they can also suffer from backlash. At the global level, we are also working with the different entry points, such as the Secretary General's Rule of Law Vision, our Common Agenda, and the Office of Secretary General, SRSG on VAC is very much involved in this also. We have a global focal point on the rule of law, and TEA has many hats supporting the SRSG on VAC. We also have the UN Task Force on Children Deprived of Liberty that works on the recommendations of the global study, as well as different global compacts on migrants and refugees. Last May 24, we just had the global peer exchange among governments on alternatives to child immigration detention. And we have some countries, Colombia, Canada, and other countries, Mexico, who showed how they can end child immigration detention. We also have the follow-up to the World Conference on Justice with Children declaration, focusing on 4 areas: data, alternatives to detention, among others. We also work with regional bodies, and I know ICAT has very much mapped this in their article or issue brief on non-punishment principle, but making sure also that, for example, the ASEAN platform, we have the legal chapter on regional plan of action to end violence against children. We have the ASEAN Convention on trafficking against trafficking in persons, and we have a review of how it was implemented by different NGOs, making sure that we tap the UNCT mechanism, the RCs in the RC clinics that we had on child immigration detention. So I know ICAT is also reaching out to the resident coordinator and the UN country team to make sure that this is not just UN UNICEF, UNODC, but making sure that it's a UN country approach and putting it in the country program document of our different country offices, and engaging in the voluntary national review and making sure that SDG 16 is not just an option, but if it is a lagging behind indicator, it is very much in place in the voluntary review. We have mentioned that we are also working with national human rights institution and child ombudsperson advocacy on the optional protocol on information procedure, which unfortunately is the lowest ratified among all information procedures of different treaties. And we still have to make sure that this optional protocol is a reality for many children so that they can engage in strategic litigation and communications, making sure that we work with informal and traditional justice, but ensuring they are linked with the formal justice system and that they are in compliance with international standards. These are just some of the materials that you can tap on data. We have the self-assessment tool for country self-evaluation on data systems on justice for children, administrative data maturity model on justice for children, on legal empowerment. Our colleagues have developed the legal empowerment to advance environmental justice, but this can be used also in all areas, including for trafficking. We have the CRC Committee, UNICEF Joint Conceptual Framework on Child's Right to a Remedy. On legal aid, child victims, we have developed many manuals with UNODC, the role of social service workforce, and national human rights institution. We also have a lot of resources on child protection system strengthening, as you can see from my presentation, and we will be happy to share them with you. And my colleague Afruz will be sharing more resources later on in her presentation. So I hope that's a brief overview of the Reimagine Justice agenda, and later on we can discuss some key examples from my colleagues in the country offices.
Thank you so much, Grace. And I'd like to invite our colleague Afruz to come in next. So Afruz is working as a child protection specialist with UNICEF in the unit to address violence against children. We'd like to dive a bit deeper with you into the issue of online sexual exploitation and abuse. And we will open it up to questions after Afruz's presentation. So please, if you have questions, flag this in the chat to us, and then we'll have you come in after. Over to you, Afruz.
Thank you, Daniela, and good afternoon, good evening, good morning to colleagues around the world. It's really a privilege to be here. I'm going to cover three main areas in my presentation. Firstly, talking about the specific issue of sexual abuse and sexual exploitation and new forms of harm that we see in the digital environment. Secondly, I want to give you the heads up about UNICEF's global guide for improving legislation to prevent and respond to child sexual abuse and exploitation, including those forms that take place online. And finally, just wrap up with some priority areas for attention so we can improve justice, access to justice for child victims and survivors. So, setting the scene, firstly, as I'm sure everyone in this webinar knows and well and truly understands, sexual violence is a deeply disturbing violation of children's rights. And in many parts of the world, the topic is still considered taboo. It's hidden and it's stigmatized. It covers a wide range of abusive acts, and these often occur in conjunction with other forms of violence. As examples, they can occur in different contexts and in different settings. So, for example, a child may be sexually abused by a family member or a caregiver in the home, raped by an intimate partner. They may be forced into exchanging sex for basic needs like food, money, or favors. They may be sexually exploited by someone in a position of trust or authority. Of course, they may also be trafficked across borders or within borders for the purposes of sexual exploitation. And while we know that children of all ages are vulnerable to sexual violence, adolescence is a particularly critical period, and especially for girls. Our data shows us that in over one third of countries, at least 5% of young women have reported experiencing sexual violence during their childhood. But that said, there are significant gaps when it comes to research, policy, and practice when it pertains to certain groups of children, including boys, children with disabilities, and marginalized children. And I know ECPAT's on this call, and they have a really important initiative around sexual exploitation of boys. We know that harmful gender and social norms can hinder boys from recognizing that they've been victimized, and it can also impact their willingness to seek help. So there are certainly gendered dimensions to this child rights violation. With respect to the digital environment, we know that it has introduced new forms of harm, and it's also intensified existing or offline forms of sexual abuse. Perpetrators now have access to advanced methods to conceal their actions and also to target vulnerable children. And an additional factor about the digital environment is that it really means that harm can persist indefinitely. Where the abuse and exploitation of children is digitized, it can continue to circulate and harm victims in perpetuity. So we're witnessing significant increases in the online grooming of children for sexual abuse, instances of sexual extortion, live streaming of child sexual abuse, and the creation and distribution of child sexual abuse materials. And that sheer volume of child sexual abuse materials in circulation online it's really reached alarming levels. The data from the National Center for Missing and Exploited Children, the US based NECMEC, last year's data included an astonishing 88.3 million images, videos, and other files relating to child sexual exploitation. And of course, this is only one data point, not giving us the full picture, but it gives us some insights into the volume of content being reported online. In countries where UNICEF and our partners work, we know that there are underlying systemic challenges that hinder access to justice and that hinder our efforts to combat online abuse and exploitation. One key challenge when it comes to the online forms of abuse is that this rapid growth in connectivity hasn't been accompanied by sufficient legislation, sufficient education, the requisite services to ensure safe use. And additionally, many child protection systems, many justice systems are severely constrained. So there are also gaps in legislation. So really, all these pieces together means that children are, at heightened risk of abuse and less likely to receive adequate services, adequate support, and access to justice when they do experience abuse. I want to go to our global guide. So, UNICEF has received a lot of calls from country level stakeholders on practical guidance of how they can fill this gap in the legislative framework relating to online child abuse. So we worked with Quorum International to develop this global guide, and it's based on the Convention on the Rights of the Child, the Optional Protocol on the Sale of Children, the Palermo Protocol, as well as many other international and regional conventions, general comments from the UN Committee on the Rights of the Child, guidelines, model laws, and good practices around the world. Now, while the global guide, the title there you see, it's about online abuse and exploitation, the fact is that those distinctions between online and offline abuse can be blurry, and perpetrators often use a combination of methods. So the guide actually is covering child sexual abuse and exploitation generally, including those specifics for online abuse. On this slide, I just have to really give you a heads up because of our time, and I really encourage you to go deep into the guide, which is available online. The site is there on the slide, and perhaps Daniela can also kindly put it in the chat for us. We cover all these elements of legislation, but also how to implement the legislation. It also includes good practice examples from a range of case study countries. So again, I really encourage you to look at this document. We also have a summary version available. I'm just going to quickly highlight some of the key points before wrapping up. So obviously, under international law, under the Convention on the Rights of the Child, states have an obligation to criminalize these crimes, and the offences need to be covering, the whole kind of chain of events as it relates to child sexual abuse and exploitation. The offences also need to account for new issues that we're seeing that have come about with the online environment, such as cyber stalking, cyber flashing, and the complex issues that are raised by self generated content. I want to just focus a little bit on this last point on this slide, which is the reference to the removal of the statute of limitations in relation to child sexual abuse offences. This is a key part of UNICEF's Reimagine for Justice agenda. And the statute of limitations, as I'm sure many of you understand, is the term that's used in national law, which sets the time period from when the offence has been commissioned to when, after which a suspect cannot be prosecuted. So the Committee on the Rights of the Child explains that child victims of these kind of crimes are particularly unlikely to report the crime, or if they do, they're only likely to do so many years after the crime has been committed, and there are feelings of fear, there is shame, there is guilt that are often associated with the reasons why children do not report, or if they do, they do not report, when they're older, when they're adults. And for these reasons, the committee has recommended that state parties avoid establishing a statute of limitations in relation to these offences. Let me just quickly flash and mention these other headlines because I know I have to wrap up. Obviously, the digital environment also necessitates new protocols regarding the investigation, storage, and preservation of electronic evidence. So these kind of things also need to be provided for in legislation and in supporting, supplementary guidance for countries to be able to investigate and prosecute these crimes effectively. Very important. Of course, countries have an obligation to promote the recovery and reintegration of child victims. And access to justice, goes beyond, as Grace mentioned, it goes beyond these formal legal processes and it encompasses broader forms of justice and reparations. So some of these points are just highlighted, signposted here on this slide. Very important point to emphasize here is that legislation alone is insufficient to address this issue. As well as, your primary legislation, there needs to be secondary guidance to help the duty bearers actually implement. But of course, there also needs to be the adequate capacity building, there needs to be education efforts, and there needs to be, investment in those services that need to respond. Looking forward and to wrap up quickly, we would say that in this area of online abuse and exploitation or child sexual abuse and exploitation generally, we need to focus our areas and our priorities in three key aspects. So firstly, the need for policy and legislation to be improved so that the range of child sexual abuse and exploitation, including those challenges posed by the digital environment, are captured. And these align with international children's rights standards, and that the duty bearers have capacity to implement this. Secondly, it's about service delivery, really ensuring that this is strengthened to better support children who are affected by child sexual abuse and exploitation. So, this includes systematic capacity building for frontline staff and also improving those linkages between law enforcement and victim services. And then finally, we really need to promote social and behavioral change. So there's various ways to do this, including integrating curriculum on safety and healthy relationships into schools, implementing parenting programs, leveraging digital platforms, a whole raft of efforts that we can use to really make a significant stride in combating child sexual abuse and exploitation. Thank you.
Thank you so much, Afruz and Grace. And we'd now like to open it up to any questions. I know, Dragan, you had a question. Please feel free to come in to unmute yourself.
Thank you, Daniela, and thank you for organizing this excellent webinar. I have a question for Thea, Mukuti, and Grace, and they can choose who will reply. And it's about the non-punishment principle. And thank you for raising that issue. It's a huge issue here in the United Kingdom. About 50% of all victims of human trafficking in the UK are children. Almost 2,500 were referred into the system in the first quarter of this year. The great majority of those children have been exploited for criminal activity. Albanian and Vietnamese children are used in cannabis farms, and the UK children are used to distribute drugs across the UK, so-called county lines. There is a statutory defense in the law, but it's not perfect. For instance, an element of means is still there in the definition. So I wanted to ask you if you could have examples, recent examples, preferably, of best policy and practice from across the world, which we could use for our advocacy work here on further improvement of the policy and practice in the UK in response to a most concerning issue of criminal exploitation of children. Thank you.
Colleagues in ICAT, will I take that? Or I will refer to the ICAT issue brief, but let me take it first and then maybe my colleagues. I think, Dragan, that's a very important question. But the problem is, as presented in the issue brief on the non-punishment principle, the principle itself, the threshold of the principle is not consistently stated or defined. And that's the problem, right? In the mapping done by our colleagues in ICAT, they have, outlined. I was looking at UK, if UK was there, definitely because of the issue that you've mentioned, the Council of Europe Convention, it says that the threshold for applying the principle is the victim was compelled to do the act concerned. ASEAN, it must be directly related to the acts of trafficking. And the different parliament would, so the problem is the threshold itself is not clearly defined on what is an action or direct consequence of their being a victim of trafficking. And that's why in my presentation, I can, of course, it's also the proof and the threshold that is used by the country, by the different countries. So I would say the good practice would be when the threshold is broad enough to consider that victims of trafficking are victims of the protection system, or a child in conflict with the law can be a victim of trafficking, can be a victim of sexual exploitation and abuse. Dragan. Secondly, that's why I'm presenting the Reimagined Justice agenda, is that because when a country does not have a good threshold like the United Kingdom, as you were mentioning, I'm just saying your I'm not saying what am I saying? As per your example, as per your example, if there are countries that do not use the proper threshold or the broader threshold, then they must look at a child if they committed a crime, whether the child is a victim of different elements, whether it's trafficking, it's abuse. And that's why we're saying you should not ever detain a child or put them in an institution. And for cases of immigration detention, definitely that's a no-no. It's not even the threshold, just the threshold that you're looking at, but it's also the CRC Committee on Migrant Workers saying that if a child is there because of migrant as a child on the move, definitely they should not be detained for that reason alone. And then my colleagues, in the recommendations also of ICAT, they were mentioning different recommendations to the police, to the different judges on status offenses, status defenses. And there it also boils down to having a child-friendly justice system when they interpret not just the law, the law, the letter of the law, but also the spirit of the law, because they ratify the CRC, making sure that they look at these children as victims, even if the law does not follow the threshold that we hope they would follow.
Thank you so much, Grace. I see we do have another question in the chat from Suan, but we're a little bit pressed for time. So if I may ask Grace and Afrouz to look in the chat, because I know we have a colleague that is joining us from Australia. Emma, I would like to invite you to come in. So Emma Smith is a counter-trafficking specialist working with IOM in Romania, but based in Australia, and she'll be taking us and introducing us to a project called Leading a United Pathway to Anti-Trafficking Action, and taking our conversations from the global to the country level. And please, in the meantime, feel free to use the chat to follow up. Thank you.
Thank you, Daniela, and thank you for having me to share some of the promising practices that have come from a pilot project which was funded by INL and implemented at country level in Romania between 2021 until earlier this year. And I thought the best way to share some of these promising practices was with a case example or of a story. A little bit of background information, nearly 50% of identified victims of trafficking in Romania are children. So Maria was from a small village in Romania where she lived with her mother and grandmother. They lived next door to Victor and his mother, and Victor worked abroad but came home often with gifts for his mother, for Maria's mum, and for other people in the village. When Maria turned 13, Victor began to give her more attention. He would tell her how beautiful she was. He began to bring her gifts as well. And Maria's mum really liked Victor. He was smart, he was charming, he was generous, and he was always there helping others out in the village. When Victor was away, he would message Maria on social media, always complimenting her, commenting on her pictures, and telling her how wonderful she was. Eventually, Victor asked Maria to be his girlfriend, and Maria said yes. Victor wanted Maria to visit him abroad and bought Maria tickets. She was really excited. She'd never left Romania before. But Victor had used the lover boy method to recruit Maria into sexual exploitation, and he was part of a larger criminal network. Lover boy is a very common recruitment method in Romania. So eventually, Maria was identified as a victim of trafficking by authorities in the destination country, and IOM then facilitated Maria's return to Romania. But removing Maria from the trafficking situation and assuming that she would be able to access justice. So even with legal assistance and knowing her rights and a law enforcement team that was working to investigate and work towards the arrest and prosecution of Maria's traffickers, there were real barriers for Maria in accessing justice. So Maria had suffered extreme trauma. She faced a number of psychosocial challenges. She had not been attending school during her exploitation, and she needed medical treatment. Further, with Maria from a remote village, living with her mother who had financial and emotional vulnerabilities, there were additional challenges in ensuring that Maria would remain safe upon her return to Romania. Maria's trafficker was a friend of her mother and he wasn't yet arrested. So coercive control and re-trafficking risks remained a real concern in this case. After a number of negative experiences whilst Maria was being exploited, she also held a severe mistrust in law enforcement. So what Maria's story shows us that without taking a child-focused, trauma-informed, holistic approach, justice isn't going to be achieved in cases of child trafficking. So the starting point for Maria was the appointment of a victim protection coordinator to work alongside her case. So a victim protection coordinator, or a VPC, takes on a case management role. And part of that role is to ensure intersectional cooperation between justice, child protection, anti-trafficking authorities, and individualised support services, and to ensure that those actors involved in supporting Maria and helping Maria be able to access justice are acting in a trauma-informed and child-focused way. So the Victim Protection Coordinator coordinated an individualised care and protection plan for Maria with Maria. So this addressed the multi-sectoral needs that we've talked about Maria requiring. Psychological support was organised and arrangements were made for Maria to continue her education. But although Maria had agreed to participate in this assistance program, she stopped attending. Through regular delivery, evaluation and success evaluation of the assistance that Maria was receiving, the VPC was then able to identify what it was that actually was stopping Maria from being able to attend. So it was identified that the barriers stemmed from her not being able to access transportation to get to the sessions and a lack of financial means of her family as a whole. So this was then impacting her relationship with her family and their willingness to support her in participating in this program and throughout the process. Maria's VPC was then able to coordinate the extension of support to cover the financial needs connected to Maria continuing her education and continuing to receive psychological counselling. And this then alleviated some of the family's concerns and led to them being more supportive and approving her participation in the assistance program. Another strength or outcome of the Victim Protection Coordinator being involved, it meant that they were able to observe indicators of coercive control and dependence on the trafficker during their interactions with Maria and her mum. They were able to see that the trafficker had control not just over Maria, but also her mother, and that the trafficker was taking advantage of the mother's financial and emotional vulnerabilities. So this meant that the VPC was able to work with child protection authorities in a way that would be able to safeguard Maria further by providing her mother with additional specialised support. So part of this process was giving her mother psychological support and assistance in finding a job. It was assisting her mother in rebuilding her relationship with Maria. Through specialised psychological assistance that Maria received, she was able to recognise the exploitation and control that she'd been subjected to. During her reintegration period, Maria's VPC and psychologist identified that Maria was continuing to engage in criminal-orientated and drug use social circles, and they were able to provide Maria with appropriate psychosocial education to improve further knowledge around her rights, relationships, warning signs, and to be able to use assertive where safe communication. Maria's distrust in law enforcement and her family's reluctance in her participating in the criminal justice proceedings was a further barrier for Maria. But the Victim Protection Coordinator with Maria's lawyer, law enforcement and anti-trafficking authorities were able to give Maria and her family proper information on what participation could look like if Maria chose to participate, Maria's rights, different choices that Maria would have throughout the process, reassurance of the confidentiality of the procedures, the benefits and disadvantages of participating, as well as different options for adaptations and protective investigation and prosecution strategies that would be available. So it wasn't until these things were put in place that Maria was able to actively participate in the investigation and criminal proceedings. Another key part you'll see at the bottom of the screen there is consistent and specialised legal assistance. So whilst many countries do safeguard a child's right to receiving free legal assistance, they don't imply that that child's going to receive the same lawyer throughout the whole legal process, nor do they imply that that lawyer is going to be use trauma-informed legal practice or be specialised in trafficking in persons. So this often contributes to re-traumatisation, decreased participation and understanding, and another barrier for children in accessing justice. Because Maria had continuity in specialised legal representation, she received predictability, security, and trust in her lawyer. She didn't have to keep retelling her story multiple times, and this reduced her risks of re-traumatisation throughout the process. The victim protection coordinator, the psychologist, and the lawyer's interactions then also lay the foundation to take a more coordinated platform for investigation and prosecutors to take a more child-focused approach. So they were able to work holistically with law enforcement to ensure that law enforcement was using child-focused interview techniques. So techniques that would take into account the specific vulnerabilities and needs that Maria had. A new tool was piloted in Romania to use judicial psychological evaluations to support Maria's well-being, to assist in corroborating evidence and to demonstrate the effects of exploitation. The provision of child-friendly rooms was also something, and the provision of that child-friendly room to Maria to allow her to express her feelings, to support her resilience, and to provide co-regulation and sensory supports for self-regulation was paramount in Maria being able to engage in the proceedings. So Romanian courts have been criticised by the Council of Europe for lacking national practices to protect child victims of sexual assault. So the government more recently has brought in regulations which mandate that each county needs to establish private hearing rooms for child victims of crime, as well as standardised child-friendly questioning methodologies. So there's now several examples of these rooms popping up across Romania, and we're hoping to see a lot more of these. Maria's lawyers' continued involvement also meant that they were in a position to formulate appeals against procedural acts that might have impacted Maria's safety, rights and interests. So, for instance, bail or plea agreements. Maria's lawyer was also aware of a financial investigation which had led to hundreds of thousands of euros worth of commodities being confiscated from the criminal network that had trafficked Maria. So this provided then an additional avenue for Maria to be able to access compensation. And that holistic involvement, again, of the psychological assistance and the victim protection coordinator meant that they were able to support the lawyer's submissions and application for compensation and to demonstrate the psychological impact and the ongoing vulnerabilities that Maria had experienced as a result of the exploitation. So Maria was supported under the LUPTA project. So LUPTA means to fight in Romania. And you can see there's three main components and aims of that project down the bottom of the screen. Effectively, 4 multidisciplinary task forces were established, and they operated in 4 distinct regions based out of key courts of appeal, and then 15 counties fed into those courts of appeal. So it was a pilot project to start looking at how these multidisciplinary task forces could work together. So the task forces included law enforcement, prosecutors, child protection, anti-trafficking authorities, social services, psychologists, and the victim protection coordinators. So this was a project of a lot of promising practices that really highlighted the need for trauma-informed coordinated multidisciplinary assistance. So the project itself wasn't specifically aimed at child victims of trafficking, but it certainly highlighted the real needs that children have and the individual and special needs of children. And it also really did flesh out a lot of promising practices specific to children. And so the use of this coordinated multidisciplinary assistance really protected and upheld rights further. It addressed individual needs, but it also recognised, particularly for law enforcement and prosecution, it recognised the corollary that taking this coordinated approach was going to increase informed and consensual victim participation in proceedings. It was going to improve and have more successful investigations and prosecutions, and it meant that children's access to justice was fostered and improved. So where's Maria now? Maria is back with her mother, who's now safely able to provide for Maria with her employment. She's attending school and receiving holistic assistance and psychological support. She is empowered to recognise healthy and unhealthy relationships and red flags. The criminal network was broken down and Maria's trafficker was convicted. And Maria's experiences were recognised under the law, and she received financial compensation for moral and physical damages. So despite the barriers, this child-focused approach that was taken and this more holistic, coordinated approach meant that Maria was legally empowered to access justice in this case. Leave it there. There is also a toolkit that's been used for training some of the authorities in Romania following on from the end of this project. So I'll share that in the chat as well.
Fantastic. Thank you so much, Emma, and we'll make sure to share the presentation. Just to see if there are any burning questions for Emma, please feel free to raise your hand or to post in the chat so that we can make sure to bring you in. And if I don't see anything right now, please, we can always bring you in later if you have any questions for Emma or Grace and Afrouz. But for this next part, I'd like to hand it over to one of the ICAT co-chairs. So my colleague Hanna Antonova, she's an expert on trafficking working with IOM. And she will be bringing in some of the colleagues that are with us on this call to dive deeper into some of the issues that we've already touched upon. So over to you, Hanna.
Thanks so much, Daniela, and thank you to all the presenters from this afternoon session. It was a fantastic setup. We had Grace with more broader and global agenda, and then we had Afrouz zooming in on a specific guideline, on a specific issue, and then we had Emma zooming in on an individual child's case. So that's fantastic. We had before. We move on to the some of the interventions that we had lined up from our virtual floor. We had a question from Suan in the chat, which I saw that was addressed, but the question was that oftentimes we see that parallel systems are being created for children affected by trafficking instead of building more on the existing justice, criminal justice systems and just existing child protection systems. So I wanted to also get Emma's perspective. Would you say that this is also the case in Romania or some of the other contexts that you work on? Maybe you could bring them up as examples of integrating anti-trafficking work into these existing systems and strengthening them this way. Over to you, Emma.
Thank you. I think it is the case in Romania, unfortunately, that it is still viewed as quite a separate section, but the implementation of these multidisciplinary task forces, so the Loopta project sort of saw the first demonstrations of how this multidisciplinary cooperation could work to support child victims of trafficking, and over the last year, the government has now been implementing multidisciplinary task forces on a smaller scale, but within child protection authorities in every county in Romania. So we'll be really interested to be watching that space and seeing how that's going to work.
Thank you so much. And Denise is asking in the chat whether the tools that you mentioned could be shared for other contexts. In the meantime, we do have a few interventions from the virtual floor lined up, and our first one is from Alisa Gbercik, who is a member of Interpol's Human Trafficking Expert Group and a member of the Global Association of Human Trafficking Scholars. She is also a certified human trafficking investigator and has worked with law enforcement in the US, Canada, and South Africa, as well as stakeholders in Europe on training and research to identify and disrupt criminal networks. Alisa, there's general consensus that survivors of trafficking should be included into all aspects of counter-trafficking work, and yet in practice, we are still not there. So maybe you could talk a little bit about what states and other stakeholders possibly could do to ethically engage with survivors of child trafficking. Grace mentioned that one of the recommendations of the Reimagine Justice for Children agenda is to enhance awareness raising for children so that they can know their rights and they can be better participants of the process. But maybe you can bring up some other examples, and while you're at it, also maybe elaborate a little bit more on why this is so important. Thank you so much, and the floor is yours.
Definitely. Good morning or afternoon, everyone. My name is Elisa Gabiorchik, and I'm representing the Second International Survivors of Trafficking Advisory Council, and we are officially launching on the 22nd, so I'll put a link in the chat for that. I'm truly grateful for this opportunity to speak before all of you today. Before I begin, I would like to mention that the following statements may repeat previously mentioned recommendations or efforts. However, I want to emphasize that I'm speaking on behalf of all child victims as a survivor myself. So first, states must recognize that protection and proper engagement with survivors of child sex trafficking is for all children, regardless of their economic status, country of origin, family structure, ethnicity, disability, or other perceived difference. The victims of child trafficking come from all walks of life, all backgrounds, and often have their vulnerabilities preyed upon, which I will mention a little bit more later on. These can include children fleeing war, natural disasters, and other humanitarian crises. So states need to ensure that they have a robust child protection services in place that include utilizing therapeutic approaches, medical treatment, and a strong post-release integration support system. They must approach the survivor in a way that considers the severe trauma that they have endured, ensures that they feel safe, that they know their rights and the ability to claim them, and is provided with a spectrum of care that is needed, taking into account their age and ability to comprehend the aforementioned items. This information should be conveyed in a way that is age appropriate and does not cause additional harm to the child. So it is vital to coordinate these the efforts of the state to include justice, child protection, and other allied care systems that should all be part of this engagement with the survivor. In addition, states should also work with key partners such as ICAT, where we have members with lived child trafficking experience, both male and female, to basically enhance the empowerment of the survivor's voice and to serve more survivors of child trafficking. Survivors of child trafficking should never be treated as though they are themselves criminals, and instead they need to be provided with legal aid, representation by specialists or experts, and any necessary services. The state should protect the child from detention, inhumane treatment, and make any legal reforms needed to ensure that they are treated as the innocent victims that they are. This is important because often survivors of child trafficking, or survivors in general, are re-traumatized through the process itself, worsening the mental and the physical effects of their experience. The survivor, whether they are a victim of sexual exploitation or violence or any form of trafficking, the state should basically focus on providing them justice. They also should serve and encourage future survivors of child trafficking to speak up because they know that they are safe, that they are being heard. In addition, that they are protected from retribution and will be given all the services that they need. This can be a very challenging process for a survivor to go through who has already experienced so much trauma. And so there should be this should be embedded in a child-friendly, gender-sensitive way. And these processes and procedures should take those things into account while they're doing it. This is where the collaboration between child protection services and the allied systems is so crucial in providing that kind of holistic, complete approach to helping the survivor through their journey of healing. And I emphasize journey because it's a journey for sure. States must also understand the root causes of child trafficking, the process of exploitation, as well as the vulnerabilities that our children are facing today. This should also include an increased attention on the internet facilitated child trafficking or child exploitation and how the advancement of cyberspace makes children vulnerable to becoming victims. And that is one that I would really like to emphasize greatly because that's an area where I actually work, and it is it is moving drastically, and the technology is advancing, and they're coming up with more approaches and methods and how to use cyberspace to their advantage in trafficking and learning in our children.
Thank you so much, Elisa. It's indeed incredibly important when we develop systems and we try to develop the capacities of these systems and build processes to always be cognizant of how these systems and these processes and the practitioners who work in these in them look from the perspective of the people for whom they're built, for the survivors, and without the contribution of survivors. Without their perspective, we would never be able to see this dimension. This year, ICAT is working on an issue brief on survivor engagement, and it's doing so in cooperation with ISTAC. I believe there will be a consultation on the 1st of July, and I look forward to seeing you there and working more on this with you. And hopefully this resource will become available this year, because it's extremely important, and particularly the sensitivities surrounding the engagement of survivors of child trafficking would be some of the things that we'll spend probably a lot of time discussing and integrating into this paper. So thank you so much.
Thank you.
If you have any questions specifically to Elisa or to anyone from the interventions from the floor, please paste them in the chat, and we will address them after the interventions. Our next speaker is Guillaume Landry, who is the Executive Director at ICPAT, the International Global Network of Civil Society Organizations, which has been working on research and advocacy to eliminate child sexual exploitation since 1990. And they work together with a range of stakeholders, from governments to the private sector to the general public. So Guillaume, please come in and share with us, in the context of what we discussed earlier today, within the Reimagine Justice for Children agenda, some reflections from your work at ICPAT on how we can make justice systems more accountable, because Grace in her presentation dedicated some time to discuss this issue of accountability, and particularly so for child victims of trafficking. Over to you, Guillaume.
Thank you, Hannah, and thank you for ICAT for the invitation. Greetings from Bangkok. So no fancy PowerPoint. You're stuck with my face for a little bit, so I'll try to be entertaining or interesting or both. But I suppose at this point, the emphasis of my presentation is indeed to look more at the experiences of children. And ICPAT had the chance in 12 different countries to do conversations with survivors and see how they've experienced access to services once that crime has been committed. And that's a journey we continue with more and more countries coming on board. And interestingly, recently we were in Nairobi with civil society movement from Eastern and Southern Africa, who were challenging the concept of justice, challenging the fact that we build too many projects where we're going to monitor and measure our success by the number of conviction, the number of prosecution, the number of children who will enter the system, basically, but never they see indicator that is about the experience of the children. How do they feel at the end of it that this was tantamount to justice for them? And really sort of having a conversation about the complexity. I like the work that Alisa, you've put that journey on justice. And for some children, it was very interesting in their words that they say, well, it's not so much about chasing the person who was responsible for it as being my priority. It might be more a question of being heard, being believed as the most concrete aspect of what justice meant to them at that very moment, and sort of bringing that justice system beyond the courts. And so it was great in Grace's presentation to see, you know, the social workforce and really sort of seeing that sort of social dimensions to justice is really critical in that sense. As you know, ICPAT, we've led together with UNICEF Innocenti Research Center and Interpol the Disrupting Harm Research. 13 countries have been completed on that end in Southeast Asia and Eastern and Southern Africa. There are 12 more countries now being examined on that remit. I think it's always a challenge when you produce so much data in a process that it can be reduced to a communication strategy. It's a nice report for other people to read and discover what the problem is about. But in effect, even for us, ICPAT, there are data in those reports that are challenging the status quo, challenging the approach that we're having. Disrupting harm is telling us that the children don't disclose. The majority of the cases are only known among children. They don't trust adults to handle this properly. They feel that it's going to get worse if adults get involved. And when we say adults, it can be the family, it can be the teacher, the people that are very close to them. We know that even when it comes to online sexual exploitation of children, 70% of the perpetrators are within the circle of trust. This is a key data that is challenging the depiction of sexual exploitation online as being something that someone from the dark web is really attacking them from the unknown to the children. And it connects with a question that was asked by Dragan as well. How many children are in conflict with the law at the same time that they're victim of sexual exploitation of children? And most of the time when we, the UN agency and the NGOs are training practitioners, we constantly refer them to the perfect victims, but it doesn't reflect the realities that children experience. A recent study done in Canada was demonstrating, with a process of child participation, that children don't recognize themselves in the way we represent sexual exploitation in the prevention strategies. And we have a problem there where we find it's too difficult to look at the context where children abuse other children, they recruit other children, they've been in possession of drug. In the context of sexual exploitation, they have to provide the drugs that the offenders are asking for. There's all sorts of layers of complexity, and the children are telling us it's more complicated than that. And we're failing in our prevention strategy to address those elements in many ways, and we're accountable to those realities. Last week in Tashkent in Central Asia, we had a consultation that yet again was demonstrating the problem. In Mama Fatima's report in November to the Human Rights Council, she focused her study on compensation and reparation. ICPAT did a preliminary study to feed into that report. Out of the 44 sample countries that we examined, mind you, Emma, Romania was not one of them. So maybe that would have been a good case study to examine, but unfortunately we didn't choose that country. So there were 44 countries examined, and 42 out of the 44 had specific provision that totally allowed children to access reparation and compensation. Yet out of the 16 countries that we examined with Bread for the World in a more in-depth study, none of the civil society organization and the children had heard any cases that this was actually brought to fruition and that was a concrete reality to the children. So I think that's a key element maybe as a takeaway for us, the UN Agency International Organization, and that reflects a little bit on Grace's presentation on the prevention side. In the remit of all the things that needs to happen, we know that we need better policies, better legislation, better services, decentralization, human resources, budget, and all of those things, fine. But then when comes the time to write proposal and focus on certain things concretely in a given country, we all tend to go to the upper stratus of the child protection system. And that means in reality that we go to that zone of comfort where, yet again, revisiting the policies in the legislation, there are always loopholes, so you can always go with another legal reforms. And you can go then with a plan of action that will come across that element and so forth. And then after decades of works in that regards, we know that the legislation is pretty good as it is, but there are loopholes, and we choose to focus on those loopholes in the attention and the limited resources we have. And at the same time, the children are telling us, we don't see a difference. It's not happening for us. And then we're surprised that only 2% of the cases are getting reported. And then when I say reported, it's to helpline, hotline, the social workers, the teacher, not just even entering yet the formal justice system through the police or the justice, the courts and the lawyers and so forth. So, but this is where we're embarking, saying, well, we need better laws, and then we refocus our attention on those elements. So don't get me wrong, I have nothing against lawyers and great policy reforms in that regard, but there's a little bit sometimes a complicity we can put in the fact that we're not really serious as really hitting the ground. We know implementation is lacking, yet we continue to go in the upper scale of the child protection system because we feel it's too costly, too complicated, too compromising to go in the lower level of the child protection system, so to speak, and go in the realities with the children there. A key finding from Disrupting Harm is that was a bit of a surprise. There's equal number of boys who have been seriously sexually harmed than girls. It's not true for all the manifestation of sexual exploitation, but yet boys are not a side story. And by and large, we're totally failing globally the specific trajectories of boys, and the response is built for girls, and boys are just, you know, the addition that are supposed to fit there. A little bit like the girls soldiers we failed so many decades ago. So in that moment of time where we need to be careful that the gender dimension still means that the girls are the primary victim of much of sex trafficking, sexual exploitation of children. But yet that doesn't mean that there's a space to have specific strategies to reach out boys, and there's a great need to push for this in particular. The notion that children are telling us the most important factor they see in the access of services is how the adults react. So the element of the attitude, the skills and the practice are making the most significant difference to them. It's not the booklet, the brochure, the poster on the wall. It's not the fancy procedures that comes after that. It's not all sort of the due process that will accelerate the process afterwards. It's about those elements of reaction and contacts that are made. And yet we again focus on working with specialized units that oftentimes do not interact directly with the children. And it is just the regular police officer on the corner of the street to have that possibility of establishing a contact with the child. And these are the people we fail to train. We fail to let them be part of that child protection system with those degrees of specialization between trafficking, sexual exploitation, labor, and whatever other thematic matters. So there are challenges in the way we frame our response to the issue and how we move within the child protection system. It doesn't mean to leave aside the upper stratus, but how we have a much more sort of balance and equilibrium perspective in this, and how we define justice so that we are open as well to consider that in many instances, pushing children to go to a tribunal and a process of this kind will be contrary to their children's right because of the actual realities of that system. So is that really the recommendation to have mandatory reporting, and then that's supposed to be on paper the best thing for them is to chase the criminals and go with prosecution in many instances. So that element of challenge has been brought a lot by the children, and that's something that probably would need to sort of be much more redefined. I think all of us included somehow in our plan of action, but it's just that how then we prioritize that plan. It's in that step that we're oftentimes just leaving it as a discourse, but it doesn't reach really the way we articulate our priorities. And mind you, it belongs to NGOs as well, so it's not just pointing fingers. We all share a little bit that problem, I suppose. So thank you.
Sorry, I was muted. I forgot. Thanks so much, Guillaume. There's a clarification request in the chat, but I do believe that you sort of explained what you meant by lower levels of the child protection systems. Did you mean the frontline workers, the police person on the corner when you said? But maybe you can speak for yourself.
Yes, sorry, I think it's a good point because sometimes I might use too many complex images, but within the child protection system, if you work in the circles that relates to the policies, the legislation aspects, the plans of actions, the coordination body, the overall national system, my argument is not to say this is not useful, this is not necessary. It's all good and I'm all for it. But at some point, if we just stay in that space and we're not getting closer, if we're using the concentric circle to the children are saying they don't have the services around them. The people are not trained. They cannot access to a child-friendly system. So when they come with the additional burden of having experienced sexual exploitation, that really adds a lot more sort of precaution in the way the system is organized, we're failing those realities. But in countries that have been embarking in such trajectories of working on those matters with plans of action that have been going on for 15 years, we're still at the level where on the ground we see too little impact. So how are we really centralizing much more our efforts in working at that level rather than seeing the children as an indirect beneficiary that will much later see the consequences of our action?
Thank you so much. It's indeed a really, it's a really complex undertaking to come up with a way of measuring how we actually deal with all the different complexities of these cases. And one thing that you said that resonated with me that the involvement of family and friends and people who are close to children. A recent research that is forthcoming from IOM actually found that this is particularly the case in countries affected by serious crisis. For instance, in Ukraine, Myanmar, we've seen that between 30 and 50% of children who are trafficked with the involvement of people who are very close to them, their families or friends. And on top of that, we have the systems collapsing. So is it really, like, how do we deal with those cases? How is best to sort of pivot the justice system to respond to them in the best interest of the child? That is also a big question. Emma says in the chat that we also know that children often make a partial disclosure to test the response. So this approach is key in consideration and really makes sense. Now, I will move on to the next intervention from the floor, and then if we have a little bit more time left, we can proceed with questions. Our final planned interventions from the floor today is from Liliana Sorrentino, who is a legal officer at the United Nations High Commissioner for Refugees and served as ICAT co-chair in 2022. Liliana also represents UNHCR in the United Nations Migration Network workstream on alternatives to immigration detention, which UNHCR co-leads with the International Detention Coalition and UNICEF. Liliana, Grace in her presentation touched a little bit on the immigration detention, but maybe you can come in and speak a little bit more about some reflections about child immigration detention and your work on ending it in relation to Reimagine Justice for Children agenda, because we understand that globally this remains an issue in at least 100 countries or more. So there's much work to be done. Over to you, Liliana.
Thank you very much, Hannah, and thank you, colleagues, also for the presentations. And thank you very much, Guillaume, for bringing us down to the ground. I'm afraid I will bring you up again to the policy level, but I will try to make a couple of very concrete points, I think, which we can use when we see that the actions at global level can really trigger into informing court interventions and then making a difference for individual children. So from UNHCR perspective, the first thing I would like to say is that we see a lot of cases in which we have asylum seeking and refugee children who are trafficked and then detained for violating immigration rules. So they are detained in relation to their status. And so they are in these cases, they are of course unjustly penalized twice and in violations of both the refugee conventions and in violation of the Convention on the Rights of the Child and in violations of all the anti-trafficking standards. So first I would like to recall one point which was echoed earlier on also by a question posed by the colleague from the UK on the non-punishment principle, which is even if it's not provided within the trafficking protocol is very clearly now recognized at the international level. It's in the Forced Labor Protocol, but it is recognized in General Assembly resolutions, in Security Council resolutions. It's in the instruments that are available in Europe and the regional level, from the Council of Europe Convention to the Trafficking Directive, or also in ASEAN. I think Grace was referring to the ASEAN Trafficking Convention. And I think it's quite important to point that that principle refers to when applied to a child victims of trafficking, does not require any proof of compulsion being so that the child was involved in unlawful activities, and that these unlawful activities were related to the trafficking is sufficient. There is no need to have evidence that the child was compelled to act as in this way, because the child trafficking definition does not require the means. And this is extremely important. In this case, I think we have the first case of a child punished who was a victim of trafficking, recognized, addressed by the European Court of Human Rights. And that's where I think it's nicely, links to what the point Guillaume was making, because first of all, the court clearly recognized that children cannot be penalized for failing to self-identify themselves as victims of trafficking. Not only they cannot be required to self-identify as victims of trafficking, and it's on the opposite, it's the state's obligation of implementing this non-punishment principle in within their obligations on trafficking to protect victims and also to duly investigate the case. So I think it's very, very good that the recognition of this principle comes as part of the state due diligence obligations of prevention, protection, and investigation. From the perspective of UNHCR, this principle that we see violated in so many parts of the Sahel, the eastern horn of Africa, with Rohingya, also in many countries in Asia, we have been our policy position is, and that's also our role and contribution to the working group on alternatives to detention under the UN network on migration, is that children should never be detained for any immigration-related purposes, irrespective of their legal status or that of their parents. And so detention is never in their best interest, nor in that of their families. On the opposite, we should have a proper and adequate reception arrangements for children and their families, and we should explore more care arrangement and community-based programs for them. I think we try to do this and try to support efforts in this way by promoting the complementary implementation of both the Global Compact for Refugees and the Global Compact on Migration, that both have address include the state's commitments to provide for alternatives to detention and for ending the immigration detention of children and their families. I would say that as part of this work, we have also, as Grace was referring, we have been supporting the International Detention Coalition and UNICEF in this series of global peer learning events where practitioners from states, but also from civil society organizations and from other agencies share their experiences in the mechanism, in the policies, in the practices that they have been devising to provide for alternatives to detention, and in particular to end the immigration detention of children. And I think the last event, which was a few weeks ago, had really quite a good attendance with about 140 people and a lot of interesting experiences also from local authorities. They're very often the frontline responders, and they can contribute in providing protection for these children and preventing their detention in relation to their status. I think we are also proud that we responded to the call of the Special Representative of the Secretary General on Violence Against Children and joined this UN pledge of the Task Force on Children Deprived of Liberty, so to end immigration detention of children. I think we have a lot more work to be done in concretely making legal assistance available to children and empowering them, knowing their rights, but also knowing their options so that they can seek help and they can report what happened to them so that they could be receiving care. I stop here as I think we have no minutes for discussion, maybe. Thank you.
Thank you so much, Liliana. Are there any questions to any of our excellent presenters from earlier this afternoon, and also from for colleagues who provided interventions? While Liliana was speaking, I thought, circling back also to Suhan's point on how all these efforts need to be part of the child protection system strengthening across all of its core elements that are defined in the UNICEF strategy. And we are currently working with UNICEF and finalizing a technical guidance note for governments on integrating children affected by migration into child protection systems that contain practical recommendations and best practice examples on how the entire system can respond to different sort of to children who are affected by migration in different ways, be it children who are at risk of being detained in connection with their immigration status, to children left behind, to child victims of trafficking. We hope to share that with you soon enough. I see that Daniela is already sharing the feedback form, which I think hints to me to wrap up this discussion. If there are no questions to any of the presenters or colleagues who provided interventions, I will hand over to Daniela to wrap up the session. And of course, you are very welcome to contact UNICEF or ICAT if you're interested in more information on anything that we've discussed at the webinar. Over to you, Daniela.
Thank you so much, Hannah. And I think we could have probably used a lot more time, but this is just to express our sincere gratitude for everyone who helped to organize, to present, and for all of you for coming in with interventions and also for showing up. We really think that this is a conversation starter, and in the forum you can also indicate if you are interested in diving a bit deeper into some of those topics, because we'd love to continue the conversation. I see some topics have been flagged: cross-border collaboration. Maybe just by way of closing, we'll be, of course, sharing all the resources with you, the recording, and please don't hesitate to follow up. I know for the ICAT colleagues, the next time that we'll be seeing each other will be during the policy and practice exchange with the EU anti-trafficking coordinator on 18th July, but ICAT colleagues will be sharing more, and I will release you now into I know some colleagues have stayed very late, so thank you so much, and we look forward to continuing the conversation with you. Take care, everybody.